Welcome, everyone. My name is Andrea Leiter. I'm the Amsterdam Center of International Law Director, and we have a great treat today. Ntina Tzouvala here is an associate professor at UNSW Sydney and the author of the well-known and well-received book, Capitalism as Civilization, published in 2020 with Cambridge University Press. The book was an important marker in the field of international law and received the 2022 ACIL Certificate of Merit for a preeminent contribution to creative scholarship and the Australian Legal Research Award in the book category. Her research focuses on the history, theory, and political economy of international law, and her work has appeared in numerous leading journals, such as the European Journal of International Law, the Leiden Journal of International Law, and the Journal of International Economic Law. She has also just been selected as a member of the incoming class at the Institute of Advanced Study in Princeton on the theme of emerging forces in global political economy. Despite her stellar academic track record, Ntina is known to be an enormously generous and supportive colleague and mentor. I had the great pleasure to grow alongside with her, and I'm enormously pleased to welcome her today here at ACIL, also with the support of the Sustainable Global Economic Law Project. And I will give you the floor over now. Ntina will be speaking to us on new tasks and new forces, international legal thought after neo/liberal legalism.
Thank you. What a lovely introduction, especially the final bit. That was the most meaningful part of all. Thanks so much to Andrea for having me here, for facilitating me coming to Amsterdam. And thanks, of course, to all of you for coming, especially so late in the academic year. We are at the time that everyone just is tired. So I will try to keep things tight, and I'm looking forward to the conversation. All right. So in 2022, as Australia emerged out of the prolonged period of shut borders due to COVID-19, I attended my first international conference in what was at the time over 3 years. This was a large conference, one organized by one of international law's professional associations. It was surprisingly diverse in its methodological and theoretical approaches. The quality of papers was characteristically high. The formalism was disciplined and rigorous. The critical legal work was elegant and cutting. And yet, gradually, a sinking feeling settled in. Every time someone performed a tight logical deduction, or someone else renounced the narrative of progress that animate international law's exclusion, I came closer and closer to the realization that our meeting was something like a conference dedicated to the law of the Austro-Hungarian Empire, taking place in the year 1919. Our theoretical and methodological tools were refined, but our object of study simply did not exist anymore, or at least it did not exist in the way that we assumed that it did. The events that have taken place since have only solidified this sense of dread. The second Trump administration has only made clearer its decision to disengage from international law, and more so to create new forms of global government ordering that starkly depart from the multilateral legalist model of governing the global economic and political order that emerged, especially since the 1990s. In this talk, then, I will raise and attempt to answer a series of foundational questions for the study and practice of international law in the second quarter of the 21st century. Why did the US turn against the international legal order that itself had ushered into existence after World War II, but especially after the 1990s, after 1990? What are the material and ideological factors that brought about the seemingly inexorable march towards the legalization of global capitalism to an end? And finally, how should international legal scholars, which I assume will be many of you in the room, react? How should we react to this change? I will address these questions in 3 steps. First, I will use the example of the Board of Peace to show that current US engagement with international law differs substantially from earlier examples of imperialist uses of the field. Secondly, I will turn to political economy to offer two explanations of this shift in US foreign policy. And finally, in the third part, I will offer four possible avenues for international lawyers' work if we want our work to remain engaged with reality as it actually is. The need to establish that we are genuinely witnessing something novel, so what I'm going to do in part one, is linked, at least for me, to the fact that I draw from a tradition of critical legal thinking that is actually suspicious towards claims of newness in international law. For at least 3 decades now, critical international legal scholars, especially those drawing from third world approaches to international law, colloquially known as TWAIL, have focused on history, and in particular on historical continuity as a way of making visible international law's continued entanglement with structures of domination, be it imperialism, racism, capitalism, or the patriarchy. This intellectual move, this emphasis on historical continuity, has produced indispensable historical work, and it will continue to doing so. But it cannot become in itself an orthodoxy that prevents us from seeing, let alone from explaining, genuine rupture and change. In this talk, then, I will use the example of the Trumpian Board of Peace and of the UN Security Council Resolution 2803 that established the Board of Peace in order to convince you that indeed something new is going on. Adopted in late 2025, which I would say in political terms is maybe 20 million years ago now. It feels like it happened in a different universe. Resolution 2003 concerns the future of Gaza in light of Israel's escalating violence across occupied Palestine. The resolution endorsed the US-led comprehensive plan, which envisages the establishment of a civilian body, the Board of Peace that I'm interested in, and of a military body, the International Stabilization Force, that would be responsible for the development and the reconstruction when it comes to the Board of Peace, so the civilian body, and the peacekeeping in Gaza until the Palestinian Authority completes an indeterminate list of reforms and is allowed in some imaginary point in the future to assume control over the Gaza Strip. In some ways, Resolution 2803 is not unprecedented. Throughout the 1990s and early 2000s, the UN Security Council adopted a series of resolutions that established or endorsed international form of authority as interim government in post-conflict states, be it East Timor, Kosovo, or of course, after 2003, Iraq. These administrations embarked upon comprehensive programs of neoliberal reforms that led to the haphazard privatization of state-owned enterprises, the sudden and drastic lower or abolition of tariffs and other trade barriers, that feels like a different world, and the adoption of extremely low taxes, especially for foreign investments. So in some ways, trying to economically reform a post-conflict space is nothing new, right? There is significant continuity there. A closer analysis, though, of these resolutions, past and present, can help us grasp what is actually novel and what is continuous when it comes to Resolution 2803. That's the Board of Peace resolution. And I think a very interesting example to draw, or a parallel to draw from here, is Resolution 1483 of 2003, which is the resolution that followed the invasion of Iraq, right? So even though Iraq was invaded without UN Security Council authorization, in the aftermath of the invasion, the US and the UK actually sought and got what essentially was an endorsement of their occupation by the UN Security Council. And that happened with the resolution 1483 of 2003. The Security Council granted the occupying powers of Iraq seemingly much more limited powers in relationship to the Board of Peace, in the sense that the Coalition Provisional Authority, which was the governing body of Iraq, was asked to fully comply with their obligations under international law, including in particular with the Geneva Conventions of 1949 and the Hague Regulations of 1907. In addition, the Iraq resolution made multiple references to the people of Iraq, both as victims of war and oppression, but also, at least in theory, as future rulers of themselves and the country. In contrast, the Gaza resolution, Resolution 2803, dictates that the International Stabilization Force, of the military wing of the international force, will carry out its mandate in conformity with international law, including international humanitarian law, but importantly makes no similar reference to international legal constraints when it comes to the Board of Peace. So to the civilian aspect, the aspect, for example, that would be responsible for things like reconstruction and economic reform. The only reference to international law regarding the Board of Peace is a brief mention to quote relevant international legal principles, note, not rules, principles, without any further elaboration. The charter of the board contains a lengthy reference to international law in its first article when it sets out its purposes and functions, but the vast majority of the provisions of the charter concern the architecture and decision-making of the board that, as I will show in a moment, starkly depart from established practices in international law and institutions. The most distinctive characteristic of Resolution 2803, so the Gaza Board of Peace resolution, is that it departs, in my view, from current international legal practice insofar as it reflects, but also insofar as it legitimizes, the personalism that distinguishes the Trump presidency. This includes naming Trump as opposed to a U.S. representative. So Trump is mentioned in his personal capacity as the head of the Board of Peace. The charter of the board makes this departure from formal impersonal authority even easier to understand. Following the authorization of the UN Security Council resolution, it names Donald Trump as the board's chairman, and he vests in his person far-reaching, I would say unprecedented authority for the purpose of international law. Examples. The chairman has exclusive authority to invite states to participate in the board, including an international organization to participate in its proceedings. He can terminate any state's membership subject to the veto of 2/3 of existing members. So the only way you can stop him from ejecting someone is if you have 2/3 majority of the states he has handpicked to join. He has effective veto rights over the board meetings agenda and all of its decisions. He has unlimited authority to designate his successor. And I think that's really interesting if you're lawyers, he has final authority regarding the meaning, interpretation, and application of the board's charter. What is notable here, in my view, is the departure of the board's charter from established forms of international governance through the open and combined embrace of hierarchy and personalism. Of course, liberal and neoliberal international law are no strangers to hierarchy, right? The existence of the permanent 5 members of the UN Security Council vested with veto rights and the unequal distribution, for example, voting rights amongst the membership of the IMF or the World Bank prove as much. What is novel, however, is the fact that Trump is vested with such extraordinary powers personally and not in his capacity as a U.S. representative. And I know that because Article 2 Article 3, paragraph 2, subparagraph A, because I'm a serious lawyer, of the board's charter makes it clear that Trump will serve on the board in a dual capacity, being simultaneously its chairman and the representative of the United States. Right. All in all, I think the example of Resolution 2803 and of the Board of Peace indicates that there is a significant transformation of international law within U.S. foreign policy, and I would say more broadly for international relations. The present conjuncture, in my view, differs from past U.S. efforts to justify its imperial violence and its imperial interests through creative uses of international law. Right? The U.S. always made wacky international legal arguments. Right. I think what we can observe here is a marked decline in the U.S. willingness to justify its actions using the vocabulary and grammar of international law, or using international law, for example, the structures and processes of the Security Council, but only insofar it can mobilize them to authorize its own parallel and personal structures of international governance. In the context of this emerging paradigm of managing international order or international disorder, what matters is the charismatic authority of a leader and the interpersonal interactions between leaders, with one leader, though, being placed explicitly at the top of an unapologetically hierarchical system. This shift does not necessarily entail the disappearance of formal and abstract rules, like the UN Security Council did there. It doesn't mean the disappearance of proceduralism or the disappearance of bureaucratically mediated interactions between states. It does almost entail, I think, the coexistence of two distinct ways of creating global order that differ not just in substance, but also, in my view, importantly, in form. One is formal and legalist, the UN Charter, and the other is ad hoc and personalist. What I'm going to do in the next part of this talk, then, is that I will try to outline an explanation for what I think is an epochal shift of the U.S. foreign policy away from legalism. I think U.S., and I'm happy to discuss that in questions, has been a uniquely legalist form of imperial power. In offering this materialist explanation, I want to descend from an emerging trend within international thought, and in particular, I would say more international relations, perhaps, rather than international law, that analogizes between the Trump administration on the one hand and medieval feudal legal orders on the other, that there's something kingly about Trump. And I have in mind two recent publications by Goddard and Newmark, as well as by Fox and Hollis. And this is actually, the Fox and Hollis one is about treaties that exemplify these tendencies. Both pairs of scholars agree that there's something new about the second Trump administration and that it constitutes a departure from the immediately preceding paradigm or international order. In particular, their diagnosis relies almost entirely on metaphor and historical analysis. The Trumpian practice of deals is, the trade deals, for example, is analogized with the personalized nature of the law of nations, in the medieval era, and relations and other legal relations in the medieval times. And Trump is analogized to a royal figure surrounded by hyper elites analogous to medieval feudal aristocracy, right? I have a number of problems with this explanation. The main problem with which I think is that it does not try to contend with the actual historical juncture that gave rise to Trumpism. Trumpism did not arise out of, the complications of a feudal land tenure system, which is how the medieval royalty emerged. I think it emerged out of the complications and contradictions and aporias of state-mediated neoliberal capitalism, right? So my question would be, what happened with state-mediated neoliberal capitalism? How did it create Trumpism? And ultimately, its defection from legalism that was such a big part of state-mediated neoliberal capitalism. In contrast, I posit that at least two material shifts can help us. They don't fully exhaust the explanation, but can help us understand the crisis of neoliberal legalism, especially within US foreign and domestic policy. My first explanation draws from the work of sociologist Melinda Cooper, who recently has focused on factions on US capital as a way of trying to understand the social backbone of Trumpism. And she has identified a clear division between US capitalists. Public corporations largely continue to support the Democratic Party, while privately held enterprises constitute the backbone of the political coalition that propelled Trump to power. Privately held corporations represent a personalist mode of power in the realm of economic activity. They're centered around the power and often the charismatic authority of a handful of founders who are also almost entirely men, and that's not coincidental at all. They operate unencumbered from shareholder activism, and notably in recent year pushes towards climate commitments or towards diversity, equality, and inclusion demands. They rely on familial bonds for the maintenance and perpetuation of market power and wealth. And in so doing, they embrace a socially conservative ideology that reaffirms traditional family values, gender roles, and even an open embrace of eugenics and biological explanations of differential distribution of wealth and power. The pivot of Silicon Valley that are, to a large extent, not exclusively, but to a large extent, some of them are publicly traded corporations toward the Trump coalition in the lead up to the 2024 US presidential election, does not undermine Cooper's argument, since as Cooper shows, many US tech giants might be publicly traded, but they have adopted early on legal arrangements that ensure unrestrained founder/CEO power before their first initial public offerings. A range of legal innovations, things like dual class share structures, minority veto rights, elaborate rules on proxy voting that make proxy voting very difficult, public stock devoid of all voting rights, were mobilized in order to diminish power of shareholders and expand that of corporate management, and not even corporate management, specifically the founder CEO. The structure then of many systemically important US corporations since the 1980s was altered significantly as founder CEOs assumed almost unlimited powers over their corporation. The rise of the autocratic firm has not remained contained in the realm of corporate governance. Far-right intellectuals, and notably far-right intellectuals with links to Silicon Valley, have articulated scathing criticism of both democracy and bureaucratic government, and a desire to structure political life along the lines of not just corporation, of the autocratic corporation. Curtin Yarvin, who is, I would say, unsurprisingly, a software engineer, a self-described has been working for Silicon Valley for decades, a self-described reactionary and a central figure for the modern US right, has offered one of the more detailed outlines of this vision. His understanding, basically the idea is, well, we should run public affairs like corporations, but when he goes to describe what a corporation is, he says, well, shareholders benefit from, the wise management of the CEO financially. They get financial benefits, but they don't call any of the shots. And I would say this understanding of what a corporation even is reflects not just even a transhistoric idea of the corporation, it reflects his own immersion in the corporate world of Silicon Valley, where indeed CEOs were vested with unlimited powers and shareholders benefited handsomely from their decisions, but they were not entitled to influence them in own right. So, for example, he says, quote, "Their shareholders select a chief executive to whom all employees report and whose decisions are final. In no case do they make management decisions directly." This is, in my view, not a neutral decision of transhistorical corporate law and structures. I'm not defending here a good past corporation, but I think what he's thinking about is a very particular corporation. But rather, it's the naturalization of a historically specific development of what corporate law scholar Ann Lipton has described as corporate governance authoritarianism through the removal of both internal and external checks on corporate executive, especially in systemically important industries in the United States, including private finance and, of course, tech giants. Crucially, Yavin considered this model of the authoritarian corporate governance, as I said before, to be the ideal blueprint for political life writ large. What he thinks about is a multitude of sovereign corporations where citizen shareholders can enjoy prosperous and especially physically secure lives. He's one of these men who are really afraid at all times, under the unlimited authority of a CEO monarch. And the only power that you have as a citizen shareholder is the power to live, right? If you are within the corporation, you cannot make any decisions. The only thing that you can do is to take your shares and take them somewhere else. But once you're within the political community of the monarchy corporation, you have no voice. My argument here is not that there is a straight line that connects, totally smoothly the rise of the private health corporation, the popularity of neo-monarchism amongst the US, far right, and the Board of Peace. But I am arguing that the parallels between the three are too stark to ignore. Although nominally it's an international organization, I would say that the structure of the Board of Peace resembles much more closely that of the founder-centric corporation, given the extraordinary and essentially, I would say, limited powers that they gave to Donald Trump. And I would say, in some ways, the Board of Peace attempts to put in motion Yarvin's dream of governing without even the pretense of egalitarianism, the pretense of bureaucratic control, but also interesting, without bureaucratic complexity. It's a very interesting model in which they think that bureaucracy can be eliminated. All in all, I would say that the roots of modern personalism, both in domestic and in international law, cannot be attributed to some weird historical jump in which we got a feudal renaissance. Rather, that I would say the material and ideological matrices of personalist rule lie with a distinctly modern phenomenon and a distinctly capitalist phenomenon, which is the privately held or public but nevertheless autocratic corporation and its specific centrality for US capitalism and for Trumpism in particular. Secondly, I would argue that the crisis of neoliberal legalism is directly linked to an understanding of the world economy as a zero-sum game, right? So the rise of a zero-sum gain mentality that has become prominent within the current, definitely US administration, but I think you could see more intelligent and refined versions of it also within the Biden administration. It's just, as with everything, the Trump administration has a slightly unreconstructed version, and it makes it more visible. Very often, mainstream economists treat this basically zero-sum mentality as a sort of primitive view, point, right? That you're silly if you don't understand that the world economy is a positive-sum game. I would say the reality is slightly more complicated than that. My intuition is that this rise of zero-sum thinking in this particular moment of time needs to be understood in a broader context of global economic slowdown, a global slowdown of economic growth. Known on secular stagnation, this trend plagues not only advanced capitalist economies, notably Japan has been in it since the ages, the EU has been in it, I would say, since 2008. The US growth is much sluggish than it used to be, but also concerningly, also emerging economies such as China. It's hard to think about China as a stagnating economy because it still has growth rates that far exceed those of Europe. But since basically 2011, growth rates also in China have been slowing down both markedly and seemingly reversibly. Like the Chinese Communist Party has been doing a lot to bring back growth up, and it cannot go up. So political economists, and especially heterodox political economists, have offered a broad range of explanations for this phenomenon. And I'm very happy to get into this conversation, thanks especially within the Marxian and post-Keynesian camps that I'm interested in can get really heated. And this explanation, actually, things get heated because they have markedly different domestic political and legal implications. And that's why I think they're so, the debate is so intense. However, I think I don't need to pick, and I think you don't need to pick one of this explanation to acknowledge that an explicit in the case of the US far right, or implicit in the case, I would say, of much of Western center-left and center-right parties, acknowledgement of this reality of secular stagnation is incompatible with international law, and especially with international economic law, as it emerged after 1945, or in the case of international economic law, as it emerged after 1990. Although that law was always deeply biased in favor of the capitalist core, it also assumed, and not crazily so, it assumed it because it was happening, that continuous and robust economic growth was not only desirable, but it was also possible, that it was a secular characteristic of the global economy. And therefore, gains in the global economy could be distributed amongst multiple actors, even though I would say law and economic law, international economic law, was part of a series of mechanisms that ensured the deeply lopsided distribution of these gains in favor both of particular factions of capital, but also in favor of the capitalist core. Otherwise put, I would say that international law and international economic law in particular imagine the global political economy deeply as a positive sum game, even when they ensure that the benefits accrue disproportionately toward the class and also geographical, top of the pyramid. However, this imaginary of the economy, of the global economy as a positive sum game, is hard to sustain in light of sluggish economic growth. The Western far right has actually been quick to articulate a response to this malaise, both ideologically but also practically. Ideologically, the far right has embraced, across the board, a zero-sum rhetoric that portrays gains by some, be it immigrants, women, racial minorities, the Chinese middle class, the Chinese capitalist class, as being in some way taken away from its rightful owners, those usually being, of course, white men, and perhaps a narrow group of people around them. My argument is that this is a despicable but rational response to the real material constraints posed by secular stagnation. I don't think this is a silly idea that people have. I think that's a way of solving a problem. I just think it's a monstrous way of solving a problem. that makes all forms of international, and I would say also increasingly domestic cooperation ideologically suspect. And they make arguments about positive sum mentality ring hollow in light of persistent evidence to the opposite. If the pie is not growing, there is truth in saying that everything you get, you're taking from someone else. In terms of the practicalities of economic governance, slow economic growth makes direct state intervention for the benefit of favored political allies a very obvious method of ensuring continued profitability and therefore economic survival in a capitalist system. Not all methods of state interventionism are incompatible with international economic law, right? For example, international economic law is largely agnostic towards bailouts. But some forms of interventionism, notably tariffs, are only permissible under international law, or especially the reintroduction of tariffs or the bringing tariffs up from certain baselines, are only acceptable in exceptional circumstances and usually as transitional measures. As a result, many modalities of economic governance preferred both by the Western far right, but I would say also by other parts of the Western political spectrum, are both practically incompatible, say, with the disciplines of the General Agreement on Tariffs and Trade, and I would say perhaps even more fundamentally, they enact an entirely different paradigm of economic thinking and economic governance that implicitly or explicitly acknowledges secular stagnation as an inescapable horizon and opts for distributing the diminishing returns of economic activity to political insiders, being particular factions of national capital, being our racial kins, or in the case of Trumpism, being like direct clients, right? If you scratch my back, I will scratch yours. In this political and economic context, economic governance through abstract rules applicable to indeterminate series of scenarios, so economic governance through legalism, becomes increasingly untenable. As ad hoc intervention, the ability to act quickly and decisively in times of crisis, whether the crisis is real or perceived, open discrimination and favoritism in support of national capital or support of whoever we want to support, become increasingly prominent in states' economic management. Neoliberal legalism relied on both the reality of and in the ongoing faith in economic growth. And growthless capitalism, or sluggish growth capitalism, produces forms of state and capital coordination that are at least partly incompatible with the legalism of the previous decades. That was the second part of the paper. If the arguments presented so far are even partly correct, if I have persuaded you even 50%, then it becomes evident that international legal scholarship and practice cannot go on with business as usual. Both formalist but also theoretical work over the past few decades has taken for granted, and rightly so when they did it, the real-life importance of international law. We did international law because it mattered. Sometimes it mattered because you thought it had the solutions. Sometimes it mattered in my case because I thought it was part of the problem. But being part of the problem still means that you're important, right? That's a great way of being important. We thought that it mattered, and the formalists proceeded to clarify the meaning of international legal rules, or my people proceeded to theorize about or to critique the political, economical, cultural functions of international law, but we did all taking for granted that this thing matters a lot. I would say this is an untenable starting point. This doesn't mean that international law doesn't matter, but I'm saying it cannot be a starting point that we take for granted. It needs to be shown rather than assumed. In what follows, I sketch 4 potential pathways that in this particular and particularly uncomfortable moment will allow our work to remain both intellectually rigorous and practically relevant. 4 options. Not mutually exclusive and not the only options. If you have other ideas, I'm actually very serious, please tell me. Documenting and explaining the crisis, like understanding what on earth is going on and how did we get here. First, constructing a pragmatic universalism in support of some parts of international law. Second. Third, engaging in selective, politically engaged formalist work. Yes, I said what I said. And finally, exiting the field. I'll start from the first. Many of you will find my explanations of the current crisis unpersuasive or incomplete. And they're absolutely the latter. They're absolutely incomplete. I would hope they're a bit persuasive. For the past 4 decades, the expansion of international laws, both thematic and geographical reach, and its ideological power seemed unshakable, both to its advocates and I would say curiously to its critics. This conjuncture, like 1990s to I would say 2015, made it hard to envisage that this seemingly unstoppable rise of international law could come to an end, let alone be reversed. Consequently, I would say an indispensable task of our time is to describe, evaluate, and explain which aspects of international legal order have lost their power and authority, which have remained relevant, and what material and ideological factors can explain the differences between the two. Why is the US bothering to justify the blockade in Iran using the language of international law, the law of the sea, but it does not bother to justify its bombing or its invasion of Venezuela and kidnapping of its president using the language of international law? To me, that's an extremely interesting question. And the question is, what are the factors at play there? The goal of this exercise should be both descriptive and explanatory. And I would say in the process of trying to understand the present, we can also construct better histories of international law's recent and distant past. The current crisis of neoliberal legalism allows us to identify with greater precision the factors that led to a rise and fall of different fields. The convergence is necessary for the legalization of global economic governance, and the political, economic, but also disciplinary coalitions with enough material and discursive power to sustain the rise and precipitate the fall of neoliberal legalism. So that's the first option. Second option, pragmatic universalism. This is the tough, again, argument for me to make as someone who has spent a very long time saying how bad international law is. And I would say that still holds, like the fact that international law is under siege doesn't mean that suddenly we should shut up and defend it in all circumstances. I do think that there is parts of international law that have been actively detrimental to humans and non-humans alike. And I think there is parts of international law that actively contributed to the rise of Trumpism. So I don't think that suddenly we should say all of international law is good. I also do think, and that's especially for my people, the critical people, that not all international law is bad either, or at least it's not worse than what seems to be happening. Aspects of the international legal order reflect, in however incoherent and weird ways, the demands and victories of subaltern actors, be it formerly colonized peoples, the working class, peasants, indigenous peoples, women's, and others. For these rules, institutions, and fields to survive the far-right onslaught, it is important in my mind that international legal scholars construct a renewed pragmatic universalism in support not of all international law, but of all those parts of international law that are worth saving. As openly parochial discourses of superiority are gaining traction both in the global north, but also in the global south, And they legitimize reactionary projects of open and unshamed dispossession, violence, exploitation, and removal. It is imperative for international lawyers to reaffirm, but to reaffirm by re-articulating the problematic and limiting, but nevertheless disruptive in this moment, universalist aspirations of international law. The precise contours of this affirmation are not predetermined. Tactically, for example, to go back to my example about the Board of Peace, one can imagine how affirming and emphasizing the ICJ's advisory opinion back from 2024 on the occupied Palestinian territory as an alternative canon to Resolution 2803 and to the Board of Peace might not lay the groundwork for the full liberation of historic Palestine, but it can affirm the fundamental status of self-determination under international law and the juridical equality of Palestinians as a people entitled not only to physical survival, but to full political subjectivity. Even though there are many reasons to be suspicious of juridical equality, including political equality, Resolution 2803 and the Board of Peace arguably departs from it altogether, signaling the emergence or re-emergence of an international legal order that is structured explicitly around not only material but legal inequality, remaking the case for the progressive elements of the international legal order. I would say is a worthwhile both intellectual and political exercise. Just to put it bluntly, just because the liberal versions of universalism in the 1990s were racist and naive, it doesn't mean that there isn't a form of universalism that cannot be racist and naive. The above route, so reconstructing the foundations of some form of universalism, seeks to rethink and legitimize anew the foundations of parts of the international legal order. But I think this intellectual exercise will be practically useful if international lawyers also take up the task of deploying arguments based on those progressive elements in practice. In the past few decades, theory and history have been the preferred modes of engagement with the discipline for progressive international legal scholars, at least since the 1990s. Not the only one, but I would say there is a clear concentration. This has been actually a marked departure from earlier generations of politically committed international legal work, which might have been theoretically grounded, but it was actually oriented towards legal reform and advocacy. Now, the turn away from doctrine in the 90s was motivated primarily by political distrust towards international law's emancipatory potential, but it was also, I would say, secondarily motivated by digestion of the critique of indeterminacy that made doctrinal scholarship theoretically attainable in the eyes of many. Although I would say the second problem remains unresolved, sometimes when I make doctrinal arguments, I do get a bit antsy. I'm like, oh, what is the true interpretation of law? Okay, I guess I'm doing this. The shifting political conjuncture should prompt us to reevaluate the former position, so the political suspicion. And again, I think we are right to be politically suspicious towards huge parts of international law. I'm not fully sure that this is the right moment to deconstruct self-determination. Like, I think that's a really good moment to reground it, to rethink it, to apply it. I'm not fully sure it's the best moment to deconstruct it. The final option open to international lawyers is the more demanding on a personal level. Since the early 2000s, and I would say especially for my generation since the 2003 invasion of Iraq, there has been a marked concentration of critical scholars in international law. I would say especially in some jurisdictions. I'm not fully sure that this works in the Netherlands, but I would say it works in the UK and Australia, which is the places I know the most about. Even if the Trumpian offensive against international law turns out to be somewhat of an outlier, and I think there is a real possibility that that's the case, it is doubtful that international law will ever command the ideological and material power that it did between 1990 and the mid-2010s, anytime soon at least.
No, someone does this.
Yeah. No, of course. All right. Awesome. Thank you. Therefore, if it's true that international law will not command the ideological and material power that it did for these 25 years or so, there is a case to be made that at least some legal scholars who are currently international law, we should turn our attention to those legal fields, be it property, contract, corporate law, or even more specialized fields like, I don't know, the law of central banking, the law of securities, procurement law, that are more important for contemporary constructions of political and economic power. The personal and professional cost of retraining and reestablishing one's disciplinary presence and identity are significant, and it may actually prevent many for us from emigrating out of the field. But I think they should not prevent both a collective discussion, but also personal reflection on the continued merits of ongoing engagement with a field whose real-world relevance is on the decline. On this very happy note for people who are international lawyers, I am going to stop and I will welcome your questions and comments.